our studios Tuesdays at around 7:45. And we say very good morning to you, Mr. Nico. Thank you for your time, sir.
Good morning to you and also to the listeners. And to make further disruptions, of course, today at 1:15, I'm also going to be on again. So It's going to be even more confusing for some people at that time.
Yeah, so don't miss that conversation at 1:15 this afternoon, right here on CCFm 107.5. The impact of policies and decisions that are being made in the United States of America and how it can potentially affect and will potentially affect the South African economy and us as the citizens of this country.
Okay. Today I want to deal with two issues. One relates to your home loan and one relates, of course, to your last will and testament. Now, in terms of your home loan, most of us have a dream that one day we're going to finally pay the bank.
Yep.
And then we're going to own our own property. Now, I want to explain in the background what happens. Firstly, it's going to be a good thing when it finally happens, and you're going to want to celebrate. And then the legal work starts in the background that you don't always are not aware of. The bank actually owns your property until you've finished paying. So once they have their debt settled, they've got to cancel a session on your property.
A session, it's not a music session.
No, it's not one of those. If you do Grammarly spelling, it's going to keep confusing the two words and come up with a music session instead. So what's then got to happen is they've got to find the paperwork on the original deeds trust. Now, in my case, my property had been owned by the bank for 30 years. And of course, that's when the bank discovers they've lost the deeds. So they've got to then, at their cost, get the deeds reconstituted, and the session has got to be cancelled. Now, the problem is that not many people are aware of is that you've got insurance on your building, and that replaces your building if there is damage to the structure or if the building burns down.
Okay.
Now, when your bond gets cancelled, that insurance gets cancelled as well.
Yes.
And if nobody reminds you, you are not going to replace that policy.
Sure. And that
now, that's what happened at Knysna a couple of years ago when those fires hit.
Yes.
Because a whole lot of the owners then discovered they had no insurance and they lost everything. So now you've got to, if it's the first time you're working on that, you've got to work out how you've got to get the new policy going and what value. Now, remember, the whole idea is that if that building burns down,
you can build.
You've got to go and live somewhere else.
Oh, yeah.
And the insurance must have enough money in the kitty for you to live somewhere else, for the site to be cleared, for the architect to draw up the new plan, for the new builder to build, for the security guard to be on duty while they're building so that your material doesn't go and build everybody else's house.
Yeah.
Then for you to move back in again. So the value, you've got to get that value sorted out. And the architect's going to have to help you because it's not the replacement value of the building. It's got to be more than the replacement value of the building. So now make sure that if your bond is settled, you've got the title deeds, you've got to put those title deeds in a safe place, preferably in a safe, where somebody knows where to find it if you are no longer there.
And it should be a fireproof safe.
Yes, it's got to be a fireproof safe. Yeah. It's silly to only worry about burglars. They're not going to want the piece of paper. It's the fire that's going to be the problem. And also make sure that you've then got adequate cover so that if something happens, that at least your building will be replaced and the family are not going to be worse off than they would have been earlier. So it's quite a lot of things to do, and it's only going to happen once in your lifetime, so make sure you get it right. Now, my gripe with last wills and testaments is you sit down with somebody who asks you what you want. Now, what happens if you don't know enough about the law and you say to them, if my wife and I pass away, I want my children to have a testamentary trust. Then that's what they will do. They will draw up a testamentary trust. But a testamentary trust is taxed at 45%.
Ouch.
Which is fair. But if you have a child with special needs, then that trust is not going to terminate when that young adult reaches 25 or 30 or 35. It's going to have to run for the rest of their lives.
Yeah.
And unless you've told the attorney that that person has special needs and what the special needs actually is all about, they are going to draw up the incorrect trust.
Wow.
And then the incorrect trust is going to be taxed at the incorrect rate.
Yeah.
So instead of then getting a trust at 19 or 20 or 22% tax, that person is going to end up paying 45% tax.
Okay.
So if you have somebody with special needs, I know people often don't want to talk about their personal experiences and their personal family. That's the one occasion where you have to talk about it. They will then separate, because if you've got two kids, they will in fact create two testamentary trusts. One for the child that's going to, the testamentary trust will charge 45%, and one for the person with special needs, where the tax rate will be a lot lower, simply because the state will look after that person in a different way, and the tax rate should then be lower because now the trust is there to protect, and the tax rate should then be different at an individual rate, which is why there is then a special concession made to create fairness so that that one person doesn't pay more tax than they should be paying. So when you sit down and deal with it, try and work out if there is a special situation in your family. Get some advice before you sit down with somebody who's doing one of these cut and paste wills.
Yeah, so important.
Because one of the issues I find when I'm dealing with clients is so often that trust is incorrectly put together, simply because they said that person has to make the decision on my house, and it's a special needs child who could never make the decision about what to do with the property anyway.
Yeah.
So now there's a whole lot of things that are wrong. Or the child is permanently in a wheelchair. That qualifies as special needs. And now you've suddenly got a double-storied house, and the will is not going to allow for that house to be sold and replaced with a more friendly environment.
Yeah.
So think through carefully, get some advice. Make sure you're talking to people who can help you.
That's great advice, Nico. Thank you so much. And obviously understanding just that in any situation, you need to have a will. Because if you don't have a will, what happens?
Well, it's just going to be chaos. And the rules of the law do not necessarily provide the kind of protection that you want to provide for your unique family. So yes, you do need to get a will, but a will is not just something you buy from CNA. Please, that is not a will.
Yeah.
You should never be looking at those kind of documents. Get some actual help. Okay. And if the person is just sitting at a computer doing cut and paste, I don't consider that a will at all.
Okay.
Absolutely not.
Sure. Thank you so much, Nico. Nico can be contacted via questions@northwood.co.za. But Nico, thank you for highlighting this for us. We appreciate it so much.
Sure. Thank you.
There we go.